This is Bloomberg Law with June Grasso from Bloomberg Radio.
Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to give their attention, for the court is now sitting.
The Supreme Court's new term begins on Monday, as always the first Monday in October. But unlike other terms, the justices are returning to the bench under a cloud of ethics controversies and with public opinion of the court at a historic low. According to a Gallup poll released today, just 41% of Americans say they approve of how the court is handling its job, while 58% disapprove. And the justices will be diving back into the culture wars, tackling controversial issues involving gun rights, voting rights, agency power, and social media. My guest is Gregory Garre, former Solicitor General of the United States and now a partner at Latham Watkins. It's great to have you here, Greg. Let's start our now annual preview of the term with one of the most watched and perhaps consequential cases, the first gun rights dispute the justices have taken up since the landmark decision last year establishing a constitutional right to carry a handgun in public. Tell us about United States versus Rahimi.
Another big Second Amendment case and an opportunity for the court to revisit the historical approach that was adopted a couple years ago in the Bruin case involving a New York law that restricted the right to carry firearms outside of the home. And this case involves a challenge to a restraining order that prevents a domestic violence abuser from possessing handguns under federal law. And what's interesting about this case is beginning with the Heller decision 10 years or so ago where they recognized the individual right to bear firearms in the home, the court had always focused on the rights of what it called in Heller law-abiding, responsible citizens to possess and carry firearms. In this case, the challenger was convicted of domestic abuse after striking his girlfriend and doing other terrible things, and then was prohibited under federal law from possessing a firearm. And he's bringing a Second Amendment challenge to that, which, if he's successful, would in all likelihood call into question a number of other firearm restrictions that apply to dangerous people or potentially even mentally ill people.
The Fifth Circuit said that while Rahimi was hardly a model citizen, he was entitled to Second Amendment protections.
And it looked at it through the lens of the court's historical analysis established a couple of years ago, which requires the courts to go back and line up the firearms restriction against historical laws going back to the 18th century. And oftentimes in these cases, there's really no perfect analog given the way in which guns and restrictions have evolved over time. And so, one of the questions at the heart of the case is perhaps the court will give us some more guidance on how to apply that historical analysis. And in this case, the government has strenuously argued that this sort of restriction really is in line with historical restrictions prohibiting those who are deemed to be dangerous from possessing guns. But that's really the nub of the dispute before the court, is a historical argument about whether this restriction is analogous to 18th century restrictions on gun possession or not.
And here you have the Solicitor General saying, well, there are some colonial and early state laws that allowed disarming dangerous individuals, and Rahimi's lawyers saying that, none of those laws apply. They seem to want a law exactly on point. This historical analysis in this context where weapons are so different and times are so different, the courts have really struggled with it, haven't they?
Yeah, they have. And we've seen a lot of cases in the wake of the Bruin decision a couple of years ago, cases challenging all sorts of restrictions that seem to have survived the Heller decision 10 years back, recognizing this individual right. And so I think as important as the specific issue is in this case, particularly for the victims of domestic abuse, I think the focus of the court's resolution is going to be to see if it can fine-tune this historical analysis to give courts more guidance in considering these challenges.
And this case could affect state laws as well. An Illinois-led group backing the administration said that almost every state either requires or permits courts to limit firearm access for people subject to domestic restraining orders.
Yeah, that's exactly right. It would apply to state laws, local laws, and that's obviously one of the government's arguments. And the court took this case right up on the government's petition, I think understanding the general importance of the issue and the need to sort of jump back in and clarify its law in this area. So this is definitely one that we would want to follow.
Let's turn now to another high-profile redistricting case to come before the court, Alexander versus South Carolina Conference of the NAACP.
Yeah, so one of the surprises last term was a case out of Alabama involving a challenge to a redistricting plan in which a majority of the court actually agreed with the lower court that the state had improperly taken race into account in drawing the districts. And so here we go again. This is a challenge out of South Carolina in which the lower court had found that the state improperly used race to draw this district, which in order to favor Republicans. And what's sort of interesting about this case is the interplay between race and politics. There's an argument that race was used as a proxy for political affiliation here. And that sort of brings into play two different doctrines in the Supreme Court's jurisprudence. One in which the court recently held that challenges to redistricting on political grounds, so-called partisan gerrymanders, actually not justiciable. And the second in which the court has always considered challenges that race was improperly taken into account in drawing district lines. And so this case presents an opportunity for the court to sort of balance those two different inquiries.
So, as you say, Republicans say they were motivated by politics, which is permissible, not race. And it seems like it's a difficult distinction to make, particularly in this case.
Yeah, that's exactly right. And that's why I'm sure it's one of the reasons that the case is before the court now. And again, it'll be interesting to see if this is one of those cases where maybe the court tacks back to the center as it did in the Alabama case last term. But this will be a difficult one. This is, obviously delicate issues in the intersection here between race and politics.
That case last term you were talking about, the Alabama case, came as something of a surprise to many that the court rejected the Republican-drawn congressional map in a boost to the Voting Rights Act. And some see that as a shift in the court's approach, or at least in the two conservative justices who sided with the liberals. So will this case show whether that's true or not, whether there is a shift?
It's definitely one to watch, June, and I think the gun case we just talked about is one as well. These are two areas where the more centrist justices on the court, for example, the Chief Justice and Justice Kavanaugh, have not been as willing to go as far as some of the more conservative justices. And that's certainly one of the broader themes that we're looking at for this term is last year we had several decisions in which the court seemed to tack a little bit back to the center. And so it'll be interesting to see whether that trend follows or whether the court will proceed on what is otherwise a sort of conservative orbit out to the right.
Next, we have social media meeting the Supreme Court, O'Connor-Ratcliffe versus Garnier and Linkey versus Freed.
Both these cases involve public officials blocking constituents who left critical messages on their social media.
Right. So, we're seeing more and more of these cases where social media intersects with the First Amendment. And these are two different cases, one involving two California school board members and one involving a city manager in Michigan. And all of them had social media accounts, Twitter and Facebook and the like, which they used in some instances to tweet about their public jobs. And when they got some criticism from some constituents, they decided to block them on their accounts. And the question is whether or not that blocking is subject to scrutiny under the First Amendment, which boils down in this case to a question whether or not the blocking is actually state action subject to the First Amendment.
And the Sixth and the Ninth Circuits came to different conclusions on that?
Right. They split on that. And the Ninth Circuit held that the blocking was state action and a violation of the First Amendment, and the Sixth Circuit came out the other way. And look, these cases may turn in part on the particular factual circumstances. For example, the extent to which the public officials used their accounts for public purposes. The officials in the cases are arguing that they actually were more private than public, and so they shouldn't be considered state action. But, again, you can see social media interacting with politics and public life and find its way into the courts. And there are other cases out there. And so this is something we're going to see more of as the Supreme Court and other courts grapple with the intersection between social media and First Amendment rights.
In 2021, when the justices turned down a petition from former President Donald Trump presenting a similar issue, Justice Clarence Thomas wrote an opinion saying that the case, quote, highlights the principal legal difficulty that surrounds digital platforms, namely that applying old doctrines to new digital platforms is rarely straightforward. That struck me coming from Justice Thomas, who wrote the decision in the New York gun case we were talking about.
That's exactly right. This is a case where they're looking at the future instead of the past and struggling to apply these doctrines. And I'm sure that that'll be one of the issues at the forefront of this decision.
Coming up next, I'll continue this conversation with Gregory Garre of Latham Watkins. And we'll talk about the court's focus on the administrative state this term and some cases targeting regulatory agencies. I'm June Grasso, and you're listening to Bloomberg. Several cases on administrative law coming before the Supreme Court this term may seem a little wonky for most people, but they could transform the way the federal government operates and alter the power dynamics between the branches. The cases target the power of regulatory agencies before a conservative court whose recent decisions have overridden the authority of agencies and reined in the so-called administrative state. I've been talking to Gregory Garre, a partner at Latham Watkins and the former U.S. Solicitor General. Greg, now we're on to the regulatory area. Let's discuss Loper Bright Enterprises versus Raimondo, where a 39-year-old precedent, the Chevron doctrine, is on the line. Will you explain Chevron?
Sure. So the Chevron doctrine is one of the most important doctrines of administrative law that has been around since 1984. And basically, what it says is that where you have a statute that is ambiguous and doesn't speak directly to an issue, that the courts would give deference to the administrative agency's interpretation of the statute. So this case involves a law that requires fishing boats in the North Atlantic to have observers to collect data and the like. And the question is whether the fishing boats or the government has to pay for those observers. And the statute doesn't address that question, but the agency, the National Marine Fisheries Service, interpreted it to require the fishing boats to pay for these observers. And the lower court said that that was a reasonable interpretation, so the courts would defer to it under Chevron. And the Chevron doctrine has come under assault by the conservatives as being contrary to the longstanding central principle that it's the duty of the courts to say what the law is. And so there's a great concern that they've sort of delegated that task to the administrative agencies. And there have been many justices, maybe 5 in this case, who'd be willing to overturn the Chevron doctrine and give the courts the sort of frontline role in interpreting what statutes mean without administrative deference.
So has the Supreme Court been chipping away at Chevron in recent years? So some say if they overturn Chevron, it wouldn't be that big a deal.
It would be a big deal doctrinally, but you're exactly right. They've been chipping away at it. And then, somewhat interestingly, they've actually just been ignoring it, giving the cold shoulder the last few years, where they won't even cite it in cases where it really is directly implicated. So in that sense, doing away with the doctrine wouldn't make a big practical shift, but doctrinally it would be a big shift. And in line with one of the, I think, big things we see from this conservative court, which is reconsidering the relationship among the branches with respect to the administrative state and scaling back on deference doctrines that have empowered the administrative state.
I believe it's been 4 times since 2019 that the court has been asked to revisit Chevron and hasn't done so. Do you think it will reverse Chevron in this case? You mentioned that there are perhaps 5 justices willing to do that.
So this case feels different. The court granted certiorari in the question of whether or not Chevron should be overruled. If you connect the dots over the last few years, it seems as though the court has tilting towards the direction of actually overruling Chevron. But it remains to be seen whether or not they take that step. And that the broader question of stare decisis is something that we've seen over the last several years, and the justices have very strongly held in different views about when or whether it's appropriate to overrule a case. But in this case, it does seem as though Chevron is on the chopping block.
I wonder if they were struggling with that while they were deciding whether to take the case or not, because it took a long time to decide how to handle the case. They scheduled it for potential discussion at 5 private conferences before announcing that they would take the case. So
that's exactly right. Obviously the decision to take the case was not a good one for the government ultimately, but the court does have the fallback option of just saying that the agency's interpretation is unreasonable in this case. But really the focus is on the broader question of whether or not the Chevron doctrine is really consistent with our legal principles and practice.
Do you agree with this, that critics of big government have targeted the Chevron doctrine much as anti-abortion groups targeted Roe v. Wade?
I think that's a fair analogy, June. I mean, it's really on the short list of cases that, would be on a wish list that this more conservative court would overrule. And it's in line, again, with the trend that we've seen in the last few years where the court has been willing to reconsider doctrines that have, on balance, favored the administrative state. So this is one where if the court took this step, it would be certainly in line with decisions we've seen in recent years.
Another agency, the Consumer Financial Protection Bureau, is before the court again. The oral arguments in this case are actually next week. It's CFPB versus Community Financial Services Association.
And this is in line with our assault on the administrative state. So in this case, though, it's a really interesting challenge. It's a challenge to the funding mechanism for this agency. So usually when Congress passes an appropriation, it specifies a specific amount that goes to the agency, typically on an annual basis. And in this case, what Congress did in setting up the Consumer Finance Protection Bureau is it said we're not going to have annual appropriations of a specific amount. You're going to get your funding from services and fees generated by the Federal Reserve. There's no requirement to go back to Congress every year. This is sort of an indefinite appropriation, and it's up to an amount that you can just sort of dip into that the agency hasn't come close to dipping into. So as a practical matter, it's basically an unlimited funding mechanism for the agency, which gives it greater independence from the legislative branch.
This is a Fifth Circuit decision that it's being appealed from. Is this a novel theory that they came up with?
It's the first time in history that an appellate court has invoked the appropriations clause to invalidate a statute. So it is certainly novel in that respect. That said, the CFPB, the agency here, is itself novel. And this is something that sort of haunted the agency a few years ago in a different case that involved a removal provision of the head of the agency. And, Congress set this agency up to be different, but because it did so, it sort of made it vulnerable to these different lines of constitutional attacks that we're seeing.
And the Solicitor General said the ruling of the Fifth Circuit threatens the validity of virtually all past CFPB actions, including numerous regulations that are critical to consumers in the financial industry. But the court refused to put it on an expedited schedule. Does that say anything to you?
I don't think the decision not to expedite it, but the government is right in this sense, that if the court were to hold that the funding mechanism is unconstitutional, then, a logical step might be to say, well, then that everything that it did with that funding should be set aside. And that really sort of tees up the second question in the case, which may be even more difficult, which is, if the court does adopt this novel appropriations theory, then what's the remedy? And the parties are very strenuously divided on that. I mean, the government says that the remedy should just be forward-looking, or that you could go back and just sever a particular part of the law, but you wouldn't say that everything that the agency has done in administrative actions or by rule is invalid.
So there's been this momentum to rein in the administrative state. Will this case be a test of just how far the justices are willing to go in that direction?
Yes, I think it will be. In part just because this is a relatively novel theory, and in part because of the implications of this theory. And so the area that we're seeing sort of an assault on is power given to the administrative state. But in some sense, the branch that is, at the heart of the dispute here is Congress. And adopting this theory would sort of place a restriction on the appropriation power adopted by Congress that we haven't seen in our constitutional history. But again, the specific appropriations law here, if you think of that way, really is unprecedented in that you've given an agency an indefinite amount of money or pool within which to dip in order to carry out its operations. And we just haven't seen anything like that in this form in over 200 years.
Could this case have implications for the Federal Reserve Board, the FDIC, and the comptroller of the currency?
It's conceivable. I mean, those agencies do have different funding mechanisms, but what's different about this case is this is a more conventional executive agency that's involved in sort of classic executive enforcement powers. And the funding mechanism here, although it draws from the Federal Reserve Board, is really different. So I think that if the court were to find this to be constitutionally problematic, its ruling as a practical matter really would probably be limited to the unusual alignment of circumstances here.
Finally, Securities and Exchange Commission versus bureaucracy. I could swear we had a case like this before about the in-house judges used by the Securities and Exchange Commission. So tell us about this case.
Yeah, this is sort of deja vu all over again. Last year, the question was whether or not individuals sort of stuck in these administrative enforcement proceedings could go to a federal court and bring constitutional challenges to the federal decision maker. In this case, which involves another individual who had gone through enforcement proceedings before the SEC, the Securities and Exchange Commission, it's actually the merits of the constitutional challenge. And it's, again, another case which sort of puts the administrative state in the crosshairs. And here, there's several different questions, but the one that seems to have gotten more emphasis is the question of whether individuals who are brought before administrative agencies in these sorts of civil enforcement proceedings have a right to a jury trial in those proceedings.
And his lawyer said that he was, quote, put to trial before a captive agency judge sitting unconstitutionally with no right to a jury and no way to escape to court. Does it seem as if the SEC has been a target for critics of federal agencies, the SEC in particular?
Well, it's a little bit of a product of its own doing in the sense that the SEC has the option of bringing these enforcement actions in federal court or before its own in-house decision makers. And looking back, it's in most of the cases opted for in-house proceedings. And in these proceedings, it's basically, home rule. It prevails in, more than 90% of the proceedings. The decisions are made by an administrative law judge who's basically, within the administrative framework of the SEC. And so it's a fundamentally different dynamic. And for individuals stuck in that situation, it really can seem as though they've got no hope. It's very different than being in a federal court before an independent decision maker. And one of those differences is that when the SEC brings the exact same action in a federal court, then the individual can elect for a jury trial and have the protections of a jury instead of just a judge as the sole decision maker.
If the SEC loses here, would that change the way that they have been bringing cases or litigating cases?
It would have dramatic consequences for administrative enforcement actions and, really require all of us to rethink that. And it would be a great boon to individuals who find themselves in that situation to have the right to a jury trial in that context would be a game changer, I think, in a lot of cases.
So this was another Fifth Circuit decision. The Fifth Circuit has a lot of these noteworthy, controversial, however you want to term them, cases before the Supreme Court this term.
So you're quite right about that. And it's really, one of the broader themes that we're seeing in this court. And some people have said it's sort of the Supreme Court versus the Fifth Circuit. It's interesting. I mean, the Fifth Circuit is now the most conservative circuit among the many. And, the kind of question that all these cases present is whether the Fifth Circuit has got out ahead of even the U.S. Supreme Court today in terms of how conservative it is and whether or not the U.S. Supreme Court feels as though it has to rein it in a little bit. And although, This Supreme Court is certainly one of the most conservative in history. As we saw last term, there's still a few justices in the center that are not necessarily as comfortable going as far as some of the justices at the far right want to go, the Chief Justice, Justice Kavanaugh. And so in each of these cases that we've been discussing, the spotlight is really going to be on those justices in the middle and whether or not they're comfortable adopting these broader theories.
It's been wonderful talking to you, Greg, and getting your insights on all these cases. Thanks so much. That's Gregory Garre, a partner at Latham Watkins and the former U.S. Solicitor General. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.